Mr. President.
The Leader of the Opposition.
Mr. President, I lead for the opposition on this disallowance motion, and I can indicate to the House that the opposition will be supporting the disallowance. The 2012 reforms, Mr. President, were truly breathtaking. It was the most drastic reduction in benefits to injured workers in this state effected in a single reform package ever. The second notable feature about the 2012 reform package was that every other reform package from all governments, and of course I acknowledge that from time to time all compensation packages do need to be rebalanced from time to time. But what made this reform package truly notable was that there was no attempt at fairness. In the past, everyone had to shoulder part of the burden of reform. In previous reforms, workers played their part by having changes to benefits. Employers paid their part by having increased premiums or increased workplace penalties or other obligations placed upon them. And even scheme agents in the past were called upon to play a role. In this package, the entire burden of scheme repair was placed on the backs of broken and injured workers. I'm just...
Point of order.
The Honourable Trevor Card on a point of order.
Point of order goes to relevance. This is a motion to disallow a regulation.
Yes.
We're now going back into history to proceeding, to legislation that was before this House in 2012. Yep. I say that's well and truly outside.
To the point of...
Let me finish before you get to your feet. Well outside the leave of the matter we're discussing here.
Mr. President, to the point of order, we are dealing here with the removal of benefits from injured workers in Clause 9, and that is what is sought to be disallowed. I'm talking directly to the issue of worker benefits and placing that in the overall context of what the Parliamentary Secretary kept referring to was fair scheme balance. So I'm responsive in one sense to what he has said and directly to the substance of the matter before the House.
All right. It's well recognised that a wide latitude to members is allowed in not only second reading speeches but also in relation to motions. However, they have to be generally relevant to the motion before. Now, I take it that the Leader of the Opposition will now proceed to Section 9, and as I'm certain he has completed his wide latitude aspect.
Thank you, Mr. President.
Wise ruling.
Just cleared the throat, Mr. President. The regulation, Clause 9, does deal with the removal of benefits to injured workers in relation to work assistance, and it really constrains that. What was notable about the legislation under which this regulation was made, which was another issue, was that there was no strengthening of obligations on employers to take injured workers back into the workplace, and to the very limited extent when I practiced at the bar and did a little bit at this at the bar, I said, and to the limited extent that I did do some workers' compensation work at the very beginning of my experience in practice, every offer of settlement from the insurance company to an injured worker always carried with it a requirement that the injured worker resign their employment. Everyone. It was just a standard course. Now, what this meant is that the injured worker was disconnected from the world of work, and which meant that when they went job hunting, they had to do so as an injured worker, not returning to their place of work, but seeking to find a new place of work. And that is a very, very difficult undertaking. And where they do find work, as Mr. Shoebridge indicated, they have to accept any work, and that often means short-term engagements, lots of travel, not necessarily working in the field that they were experienced in. And of course, the work capacity testing regime underlines that, because it tests your capacity not for the work you used to do or work for which you're experienced and qualified, but work that may not even exist. So you can have your benefits reduced or cut off because you're deemed to be capable of certain types of work, even though that work may not exist. And that means that you do need the work assistance that is curtailed by this regulation. I acknowledge that interjection. So it is, on the one hand, quite mean-spirited for the legislation to deprive the injured workers of their financial and medical benefits, or telescope the time in which they can access it, and then really essentially force them off because they're capable of some theoretical or fictional work anywhere in the state, but to not then provide them with the meaningful tools to actually get to that place of work. And I understand what the Parliamentary Secretary is about. Oh, well, this could be very short-term engagement. No, the Parliamentary Secretary. I'm talking about officers that are actually recognised in this place. The point is... No, just correct. The issue here is the disallowance of this regulation would not break the bank. It would barely be a statistical blip in the scheme finances. But it would restore some small semblance of balance and fairness by providing injured workers seeking to reconnect with the world of work a small amount of benefit.
I can't read that.
I note what the Parliamentary Secretary says about the 14-day time frame. But nevertheless, the removal of that from the regulation doesn't weaken or in any way reduce the obligation on the insurer to determine the matter properly. But that weighs out, in my view, the removal of the benefits that the Clause 9.1 affects. And that really should be balanced out and restored. There's a lot more that could be said about the scheme, and it's... No, I'm not going to.
I'm not debating the scheme.
I'm not, but, well, except to this extent. There should be a further rebalancing, and this is a very small ask. And the House should join with those of us who have indicated support for the disallowance. Because the ultimate objective in workers' compensation isn't just the payment, it's actually providing a meaningful framework to get people back into work if they can medically get back into work. And there's a whole lot of prejudice by employers about engaging injured workers, and workers often sustain permanent injury, which constrains the work they can do. Let's take this small step and provide a little bit extra assistance to help workers get back into work.